Welcome to Learn Law Better. Did your professor assign Byrne versus Boadle? Are you confused by the case and res ipsa loquitur? Stay to the end and learn the facts and the rule of law from this 19th century British opinion. Don't forget to hit the like button if you enjoy this episode and click the subscribe button and bell if you don't want to miss any future episodes. Hi, this is Bo Byes, and today I want to help you understand Byrne versus Boadle, an 1863 English case decided by the Court of Exchequer. Before we discuss the case, one interesting fact about the court's name. In the Middle Ages, the court met in a room where a checkered tablecloth was used. In Latin, ex means from, and chequer means checkered. So this court's exotic-sounding name really means nothing more than the court with the checkered tablecloth. The case begins with the plaintiff walking on the sidewalk when suddenly a barrel full of flour falls on him from above. He was in front of the defendant's shop when this happened, and the defendant was a flour merchant. Two witnesses saw the barrel fall on him, though no one knew why the barrel fell down. It was customary in that day to either lower barrels by rope or drop them but give warning to those who might be coming by. Neither of those things happened before the barrel fell down. The plaintiff was injured and was stuck in bed for 2 weeks. He sued for £50, which today is about 6,000 pounds or $8,000, 6,800 euros or 1 million yen. At trial, the defendant claimed that there was no evidence of negligence. Specifically, he argued that the plaintiff needed to prove that he, the defendant, had done something wrong. The jury ruled for the plaintiff, but the trial judge overturned the verdict, believing that no evidence of negligence had been proved by the plaintiff. On appeal, the Court of Exchequer explained that the defendant had a duty to make sure that its barrels did not fall out of its building. Rejecting the defendant's argument, the court noted that it was preposterous to ask the plaintiff to prove negligence when a barrel falls out of a 2-story building. If it was not due to the defendant's negligence, then it was up to the defendant to provide proof that someone else, maybe a customer, had been negligent in dropping the barrel on the plaintiff. And that is the case, except for one Latin phrase that has caused much mischief ever since: res ipsa loquitur, or in English, the thing speaks for itself. Almost in passing, the court said, quote, "There are certain cases of which it may be said res ipsa loquitur, and this is one of them," unquote. For more on res ipsa loquitur and how to use it on an exam, watch my episode called Res ipsa loquitur. All that this case is about is the use of circumstantial evidence in a negligence case. While there was direct evidence that the barrel fell on the plaintiff, that it came from the defendant's shop, and that the plaintiff was not contributorily negligent, there was no direct evidence on how the barrel fell out of that window. And when the defendant was asked about it, his answer was, in effect, "I don't know, but you've got to prove that I didn't do it." Rejecting the defendant's ridiculous argument, the court ruled that in cases where the defendant's negligence is based on circumstantial evidence and breach of duty is obvious, the plaintiff does not need to present evidence establishing breach of duty. Instead, the jury can infer breach of duty from circumstantial evidence. Why this result? Because the thing speaks for itself. Please leave comments below, and if you enjoyed this episode, hit the like button. Also, to avoid missing any future episodes, hit the subscribe and bell buttons. For more resources to help you get ahead, including my blog and newsletter, check out learnlawbetter.com. Thanks for watching.